Hi, I'm Caitlin, and this is Casey, and this is Noah, and we're associates on the EBA disability team. We're here today to discuss a recent Sixth Circuit case that came out called Messing v. Provident Life and Accident Insurance Company. In that case, the Sixth Circuit Court of Appeals discusses the standards relevant to seeking attorney's fees once you've prevailed on your ERISA case.
Yeah, and this is an interesting case in some ways because there are some parts of it that I really like. So for example, the Sixth Circuit overturns the district court's analysis and finds that there actually is some merit behind an award of attorney's fees. And there's a lot of good discussion about how under the King factors, plaintiff did demonstrate that there should be an award of attorney's fees. But in addition to that, there's this kind of negative holding about or at least negative for this party about whether or not they should actually get the attorney's fees because they failed to provide enough evidence of what it is what their attorney's fees were, how many hours they worked, what their fees would have been, should have been. And so, it's kind of a mixed bag in that sense.
Right. I think it's so important for attorneys, especially, to remember that under the ERISA statute, you're not guaranteed to get those attorney's fees, right? You have to prove not only that your client is entitled to them under those substantive factors, but also the reasonableness of the amount of hours and time that you worked. And here, they provided affidavits that stated that they, needed attorney's fees of a certain amount, but unfortunately, they didn't provide any documentation as to how many hours actually resulted in those fees. And so the court had nothing to base a reasonableness analysis on. And so I think the court does make a good point that it's hard to say it's a reasonable amount of time that was spent on a case when they don't have any idea how much time was spent.
Right. And so what this case shows us is what we need to do better of when we're representing clients. And that is specifically documenting the time that we're spending on cases accurately so that when we're filing motions for attorney's fees after we're successful, we can submit itemized billable sheets showing the amount of hours that we worked and providing enough detail for the court to do its reasonableness analysis.
And I really think that's kind of the core of why the court made the decision, is that it just didn't have anything to look at, right? And I kept thinking to myself, well, why didn't they just submit the itemized sheets? And maybe they didn't have them, maybe there's some other issue. But I do think it's worth noting, and the court does play around with this a little bit, is that you don't necessarily have to have the itemized statements showing all of your billable hours, but it is clear that just an affidavit or a statement to the effect of this is how much I worked and this is what you should pay me is not enough. I hate that lesson had to be learned, but moving forward in these cases, I think that I think for us in our firm, it is always going to be the itemized billing sheets, but at a minimum, you got to do something more than just because I said so, right?